It's live now. That's crazy. We're on page 6 or 9.
6.
Now we gotta start over.
Start over. You can start over.
Yeah, because if I don't start over,
Well, if you're gonna start over,
it's
I would
only gonna
record it on your
continue
phone.
from page 6, and then it's not gonna be a complete video.
Oh, from the last one.
But
Yeah.
record it on your phone because
Well, I'm live now.
it's gonna do the same thing to you when you get to the same place.
Yo, that is crazy. Unless you want to go live on your Facebook at the same time.
Should we? I'm just gonna record it.
All right, yeah. That was crazy.
Which percent you got?
There's 12 people here now, so we'll see.
Record it?
We'll see what's going on.
Record it? Yeah, just regular record. Get it, babe. You almost got it.
Yo, they cut the live. They didn't like that color of law part.
Nope.
They didn't like it.
Set it off.
They did not like it. They did not like it. So we was just live, if you don't know. We were on page 6 of this summary judgment. Someone said I violated YouTube community standards. I don't know how, because I was just reading what a cop said under oath. So this is a deposition. I'm not gonna go over the deposition again. I'm just gonna read some. I'm just gonna read the stuff.
Get into the stuff. What?
That stinks.
Yeah, I had a whole free class on the other video, but
That's probably because it shouldn't be for free. I lied to tell you. You gotta set up that box out.
YouTube is surveilled by the FBI. I know.
You can't see the old one?
Nah, the old one is
The old
probably
one
still
shows up
buffering.
yeah.
Still buffering?
Yeah, they hated.
They edited and chopped it right
Yo,
now.
remember when we was in Chicago
Yeah.
and I recorded the whole City Hall thing,
Mm-hmm.
and they got rid of all the footage?
I still got some recording of that.
You do?
Yeah.
Send it to me. So, this is a federal case where a Moor got into federal court with his Moorish ID. I was standing next to the Moor as counsel, pursuant to the treaty, in federal court, suing a cop, David Allen Pender. This is his deposition, which is David Allen Pender's own words being recorded to be used against him, just how they say everything can and will be used against you in the court of law. This is us using his words against him. So we're going to file our writ of summary judgment. He's going to have an opportunity to file his writ of summary judgment via his attorney. And then we're both going to have the opportunity to rebut to each other's writ of or summary judgment. His attorney's going to file a motion. We're filing a writ because we're commanding the courts to move based on giving them judicial notice. They cannot deny judicial notice, just like they cannot deny stare decisis and res judicata, unless, of course, they're creating more of a precedent by correcting previous, previously adjudicated cases. So if you don't believe me, go to law.cornell.edu. Excuse me, just Google search stare decisis at law.cornell.edu, which is one of the United States' best law schools. Right? You see that this is an original document. Right? The ink goes through the other side. Copies don't do that. Copies do not do that. All right. So this is this cop under oath. All right. See Moorish, free Moorish American. See that right there? Yep. You see David Pender. Yep. Under oath. Sworn on an oath. All right. He swears under oath that he is a cop. Law police officer. Right. So when you see me reference page number, you'll see that I'm quoting directly from what David Allen Pender said, based on the questions asked to him by Leonidas Jabir Bey during this deposition. All right. Oh, can you give me? Oh, right here. So again, as stated in the other video, you do not need Rise of the Moors. Go study for yourself and save yourself. We're not trying to sell you anything. We're not trying to sell you any packages or sell you information. We're giving you the information for free. We studied law on our own. You can study law on your own too. So don't get mad when we don't answer your questions because we're busy. So study law. Just like they have federal rules of civil procedure, they have federal rules of criminal procedure too. Right? And Noble Drew Ali said enforce the Constitution. Where do you enforce the Constitution? In federal court. It's called raising the federal question. So Moors are in federal court. Why? Because the Prophet said enforce the Constitution, and that's where you do it. The Prophet also said they placed their trust upon issues and names formed by their forefathers. Our forefathers established the Treaty of Peace and Friendship, and according to federal law, Article 3, Section 1 and 2, only federal courts have jurisdiction over issues upon which a treaty may be enforced, which this is the case. Also, the reason why we're not bringing criminal charges against David Allen Pender and the Commonwealth of Massachusetts is because this case was a removal from state court based on the illegal, unlawful, and unconstitutional traffic stop that David Allen Pender engaged in and stopped Leonidas Jabir Bey. So based on that fact, and the estoppel was supposed to happen ipso jure and ipso facto, which it did not happen. So instead of bringing criminal charges against him, it's civil because this issue was supposed to be removed from state court, which the state courts violated it, and then the Madam Patty B. Saris, who is now a retired judge, federal judge, opened this case in federal court after the state court.
Shout out to Miss Patty B.
Unconstitutional proceeding. So that's where we are today. All right. So the writ of summary judgment states the following. This writ of summary judgment is being made pursuant to the common law principles contained in the Federal Rules of Civil Procedure, Rule 56. The defense has no genuine dispute as to any material facts. Therefore, I am entitled to judgment as a matter of law based on the following facts, right? And our facts are going to be based on the law because issues of law supersede issues of facts. Issues of law supersede issues of fact.
That's a fact.
Because facts are built upon law. Just like the foundation of your house is built upon bricks or some type of concrete. That's the foundation. That's what's keeping it sturdy. So our arguments are based on the Constitution, which makes this a judicial notice, and they have to move the courts, or the court has to move in our favor based on that. Because again, law.cornell.edu, stare decisis is precedent. Stare decisis deals with claim preclusion and issue preclusion. Stare decisis deals with saving time, etc. So you'll see us referencing stare decisis and res judicata, right? Fact 1. The defendant knowingly and intentionally used unnecessary force by treating a traffic infraction as a crime by approaching my parked vehicle with a taser in his hand and aggressively yelling, "Is this what you want?" When this fact was brought up in federal court, the judge verbally expressed concerns as to why the defendant had a taser drawn ready at what was supposed to be an ordinary traffic stop. The defendant is barred from claiming that, quote, the defendant has no knowledge that said alleged acts were illegal and or unconstitutional, unquote, and this is a direct quote from his attorney. What was that? That was the attorney's response to the initial claim or something like that, whatever he labeled it. Right? As he claims to be a law enforcement officer, right? So he cannot claim that he didn't know what he was doing was illegal or unconstitutional because he claims to be a cop, and you'll see how we prove that on this page. As stated on July 23rd, 2020, under oath, the defendant, David Allen Pender, is on record stating the following, page 6. So you're a Lowell police officer, so you enforce law, correct? He said, David Allen Pender said, that is correct. Then Leonidas said, okay, so you know some law. Seeing as how you enforce it, David Allen Pender said, yes. Okay, so you know law. Okay. Since he claims to be a law enforcement officer, he is bound to know law, and the doctrine of ignorance of the law is no excuse applies to him in his personal and official capacity, both on and off duty. See Barlow versus United States, Germain versus Carcel, McNilly, Rennie, Kramer, and Irk, or whatever. People versus O'Brien, and People versus Snyder, criminal number 22293, Supreme Court of California, October 18th, 1982, which states that it is an empathetic postulate of both civil and penal law that ignorance of a law is no excuse for a violation thereof. If a person accused of a crime could shield himself behind the defense that he was ignorant of the law, which he violated, immunity from punishment would in most cases result. Ignorance of the law is no excuse in any country. If it were, the laws would lose their effect because it can always be pretended. Thomas Jefferson. Right? Additionally, as a law enforcement officer, he claims to be, pursuant to the full faith and credit clause of the United States Constitution, which all officers are bound by oath or affirmation, the defendant must be familiar with the fact that traffic infractions are not a crime. See People versus Battle. Therefore, no taser should have been drawn, nor should I have been punched in the face. Therefore, I'm entitled to relief, nor should he have been arrested. Right? The defendant's actions are clear indicators and proof of excessive and or unnecessary force used without warrant or cause and a blatant disregard for my rights protected by the Constitution. The defendant is also barred from claiming that, quote, the defendant has qualified immunity from his suit as the alleged acts complained of occurred within the scope of defendant's official duties, unquote. As the defendant alleged that he was responding to a traffic infraction, yet it is stated in Michigan versus Duke that police power extends only to immediate threats to public safety, health, welfare, etc., which traffic violations are not immediate threats to public safety. See California versus Farley. Since traffic violations are not crimes, which the defendant is basing the entire altercation on criminal activity, it is prima facie evidence that the defendant had a predisposition to use excessive force and is barred from basing his unnecessary use of force on my alleged conduct, as he lacked jurisdiction to even engage in said stop, as it was not an immediate threat to public safety, nor can the defendant prove it was. As stated on July 23rd, 2020, under oath, the defendant, David Allen Pender, is on record stating that, 1, he knows that a code and law are not the exact same thing. And he's been an officer for about 33 and a half years. When asked why he engaged in the pursuit, he said he attempted to pull you over for a marked lanes violation and an an illegal lane change. Then you asked, a marked lanes violation? He said that is correct. And then you asked, and an illegal lane change? He said, correct. Then you asked, which are civil or criminal? He said, those are civil. That's what he said. Oh, civil. And the lane change, what's that one? He said, so 98 or 89.4 alpha was the marked lane violation, and 89.2 is the unsafe lane change. And then you asked, those are also civil, correct? And he said that is correct. All right. And if you don't believe, you know how to believe us, right? What was that? Page 17? Let's go to page 17 of the deposition. Remember, he's under oath. He's under oath saying this. That a traffic infraction are civil infractions, not criminal. The answer is David Allen Pender. The question is Leonidas.
Those are civil.
Right? Let's continue. Then you asked, at what point did you become a criminal? He said, when you failed to stop for a police siren and blue lights, which California versus Farley stated those are not crimes. So obviously he's just making stuff up in his own mind. He said you broke several laws. When you did when you did the marked lane change and unsafe lane change. So at that point, by the time he pulled into the driveway that you pulled into, you were already under arrest in his own mind. You were going to be placed under arrest based on what? Based on his own mind, not based on the law. Because the law states, what does the law say? Michigan versus Duke. Michigan versus Duke. That police power extends only to immediate threats to public safety, health, welfare, etc., which traffic violations are not immediate threats to public safety. See California versus Farley, which means they're non-arrestable offenses. All right? You don't have to believe me. Look at California versus Farley. Speeding, driving without a license, wrong plates, no registration, no tags, etc., which means marked lane changes and unsafe lane changes or whatever the heck he's talking about, have been held to be non-arrestable offenses. Remember, this is the cop that claimed to know law. Then you said, oh, but it's in your mind. He said, that's all that matters when it comes to arresting somebody is what I think. It's not what you think, sir. Then he said, it's not what you think. You broke the law and I was going to arrest you. Then you said, hold on. It's not what the people pay you to do. It's not what your codes and regulations order you to do. It's what you say. And he says, it is what it is.
Exactly what it is. Yeah,
Then when you asked, is it civil or criminal? He just said, you failed to stop. And then his attorney butted in and said, hold on. Because he doesn't want David Allen Penner to answer if it's civil or criminal, because he just said you were under arrest in his own mind before you even stopped. Before he even got out the car, you were under arrest in his mind.
Already. He was there putting the cuffs on me in his mind while he was there.
So when you asked him, is it civil or criminal, he said, it doesn't matter. You were under arrest. Then California versus Farley says, speeding, driving without a license, wrong plates, no registration, no tags, etc., which means the marked lane violation and unsafe lane change, have held to be non-arrestable offenses. So since he had his blue lights on or whatever, that doesn't mean anything, because your duty is only to immediate public threats, which traffic infractions are not. Speeding and driving without a license and stuff like that is not a threat to public safety. So you had no jurisdiction to pull him over anyway. So since he did not answer to your sirens, you were well within your right based on the law. See California versus Farley. It doesn't matter what this cop thinks. In his mind, it matters. David Allen Pender, an officer who out of his own mouth admits to knowing law and knowing that a traffic stop is a civil issue, violated the Sixth Amendment and State versus Edwards, which states that in order for a crime to exist, there must be an injured party. Fact number 2, the information provided regarding the defendant's past of abusing his wife, see article from the lowsun.com and attached exhibits. Although after being placed on administrative leave, his wife, Melissa Pender of 18th Street, dropped the charges after David Pender signed an accord and satisfaction agreement, which is what they called it, which meant that Melissa Pender will not press charges and in no regard means he was not guilty of said charges, which means just because she said, yeah, you signed a satisfaction agreement does not mean he did not beat his wife during a drunken New Year's rant. Right? According to the article published January 23rd, blah, 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 the record and satisfaction document stated, the complaint acknowledges that she has been satisfied as to any and all injuries arising out of the incident, which is the subject of the complaint, and then I put the source. And an altercation involving a student resulting in the defendant being placed on 6-month suspension without pay, in which she was required to complete anger management training for using unnecessary force against a 16-year-old student, is proof that the defendant has a history of using excessive force. So when you read the article about the 16-year-old student, you'll see where David Allen Pender cleared the classroom of all the other students. And then you'll see later where it says David Allen Pender was unable to explain as to the origins of the marks and bruises on the student. Right? Then it says some top city elected and appointed officials said privately to the city manager, Kevin Murphy, that Pender should be fired. It was also quoted in the article that Officer Pender cannot offer any plausible explanation as to the origin of the marks and bruises on the victim. This history of the use of excessive force is evident in the case, as I was punched 6 times in the face and body slammed on the ground while in handcuffs by the defendant. To wit, my claim constitutes one upon which relief may be granted. See article from the lowsun.com by Christopher Scott, published January 26, 2017, updated July 11th, 2019 at 12 a.m. Fact number 3. As stated on the 23rd of July, 2020, under oath, the defendant David Allen Pender is on record stating that he operates under color of law, a clear violation of federal law 18 U.S.C. 241 and 242, and Article 6 of the Constitution, which states that all laws of any state contrary to the Constitution are notwithstanding. Now, this is very important. This is where the video cut last time. So let's go to page 57 and C of this deposition, right? And see where David Allen Pender, under oath, a cop, a Lowell police officer, David Allen Pender, a Lowell police officer, right? Under oath, a Lowell police officer stated on the record, under oath, that he operates under color of law knowingly. Page 57. Do you operate under color of law? C-O-L. You operate under the color of law? Yes. Okay. Are you aware that that's federally against the law? I have no clue. That's what a cop said under oath.
I get paid to know this stuff.
So
This.
this So David Allen Pender, who admits to being a cop for 33 and a half years, admits that he operates under color of law under oath, and then states that he knows law, knows the difference between a civil infraction and a crime, yet states on the record that he has no idea that 18 U.S.C. of the United States Code, subsection 241 and 242 deals with deprivation of rights under color of law and how it's a crime. Just to show you from the deposition, just to show you. He says, I have no clue. He says, you operate under color of law, correct? He says, yes. He says, okay, are you aware that that's a federally against the law? He says, I have no clue. Yet, in the beginning, he claimed to know law.
In the beginning, I don't know law.
That's what he said in the beginning. That's what he said. Okay. So then you continue to ask. Right? He says, I have no clue. Then you ask if he took an oath to the Constitution. All right, so to become a cop, you have to take an oath to the Constitution. He said, I don't recall what the questions they ask you at the time. I know it's to uphold the laws of this state in the Commonwealth of Massachusetts and stuff. So, I don't know exactly what they ask you that day when you're sworn in. So when you're sworn to the Constitution, he doesn't know what they ask you, even though it's a statement where they say, repeat after me. I state your name, and then you say, I, whatever your dumbass name is, do solemnly swear or affirm to support and defend the Constitution for the United States of America against all enemies, foreign and domestic, or something like that. So I was United States Marine. I took my oath at MEPS in 2010. It's 2020 now.
You still remember all that.
And I remember the gist of what I said. I said something like, I'm going to abide by all the rules of all the officers appointed above me or something like that. And I'm going to support and defend the Constitution against all enemies, foreign and domestic. So this cop of 33 years can't remember that. Can't remember him taking an oath to the Constitution. But he can remember that a lanes change violation or whatever it is, or unsafe lane change or marked lane change or whatever it is 89.4 alpha and 89.2. When he doesn't have an oath to that, he has an oath to the Constitution. Right, so he says he operates under color of law. So we put 18 U.S.C. subsection 241, deprivation of rights under color of law.
242.
Excuse me, yeah, 242. A direct quote from law.cornell.edu. All right, so you can just go there and look it up for yourself. And 18 U.S.C. subsection 241, conspiracy against rights.
Conspiracy. Propagandas and lies.
Then we put the judgment. This is the judgment. This is the judgment that we're commanding the courts to basically fine him under these laws, etc. The court must adhere to stare decisis and res judicata and find David Allen Pender guilty. Failure to do so will be a direct and egregious violation of the Constitution, Article 4, Section 1, and Article 6. Article 4, Section 1 is full faith and credit, which deals with stare decisis, res judicata, previous decisions made by judges. This is where you get common law from, etc. And Article 6, which is the supreme law of the land. Right? Based on the above indisputable facts, because issues of law supersede issues of facts, the courts must find the defendant guilty, because our facts is that the fact is he stated he knows the difference between civil and criminal. It's also a fact that the law is traffic infractions are not a crime. It is a fact he treated a traffic infraction as a crime. He had the predisposition to treat a traffic infraction as a crime based on his own words, because he said as soon as you didn't stop for the lights, you were arrested in his head. He had no intention on asking you what was going on. Hey, is your truck messed up? Did the gas get stuck? What's going on with your truck? Can you turn it off? Is it safe to turn off? Will it turn back on? What's going on? None of that. He said from his own mouth, on the record, that as soon as you didn't stop for those lights, you were under arrest, which is a violation of California versus Farley, which states that traffic infractions are not a crime and they're not arrestable offenses, which he stated to no law under oath. All right, so I'm showing you how issues of fact supersede issues of law supersede issues of facts. But your facts can be based on the law, and the facts of the case can be compared with the law. Right? So based on the above indisputable facts, the courts must find the defendant guilty of using unnecessary force and be fined pursuant to 18 U.S.C. 1091, which is genocide, whether in time of peace or in time of war, and with specific intent to destroy in whole or in part a national, ethnic, racial, or religious group. As such, 2, causes seriously bodily injury to members of that group. Definition, serious bodily injury. Number 2 definition, the term severe mental pain or suffering shall be applied for purposes of paragraph 1A and 1B in accordance with the meaning given to the term in section 23402 of this title. 1B as meaning bodily injury that involves E. The term serious mental pain or suffering shall be applied for purposes of paragraph 1B in accordance with the meaning given to this term severe mental pain or suffering as identified in subsection 23402 of this title, except that I, the term serious, shall replace the term severe where it appears, with the fine of $1 million in lawful money for his acts of genocide. So we're having him being fined under genocide. In the court of law, all are innocent until proven guilty beyond a reasonable doubt. Due to the reported history of David Allen Pender by the Lowell's son, there is no possible way David Allen Pender can be innocent beyond a reasonable doubt based on the documented evidence regarding Pender and his New Year's drunkard assault on his wife, the use of unnecessary force against a defenseless 16-year-old minor, and his involvement in a sexual harassment charge against a co-worker. Pender has a blatantly obvious history of abuse, and due to the fact that the police department is a fraternal order and policemen and women refer to each other as brothers and sisters in arms, he has never been charged for his crimes, and those who he has assaulted see the amount of people on Pender's side as severe opposition and most likely are unwilling to sue based on the opposition they would have faced. David Allen Pender must be fined for unnecessary use of force, genocide, deprivation of rights under color of law, violation of the Treaty of Peace and Friendship between, it should say the Moroccan Empire. That's a typo. It doesn't matter. You can have typos in your documents, and federal courts still have to read it, still have to recognize it, still have to address it. And the United States, and pay to the plaintiff and his counsel $9 million in cash, no checks, no money order, and no banking transfers or wiring under penalty of perjury. and prosecution from the Moorish nation, I do declare and state for the record, to the best of my ability, with a sound and conscious mind and heart, without malice intent, that all claims and statements made in this instrument are true, factually and lawfully based, and not made for nor intended to be used for fraud, misrepresentation, misprision, nor usurpation. It is furthermore stated and affirmed that all statements made are made in pursuant to and respect for the federal, constitutional, and treaty laws of the United States, and the natural, ecclesiastical, civic, theocratic, and national laws of the state of Morocco, so the people of Morocco, which means all you Moors, a free Moorish American national and citizen of the free national government of Morocco. I am Leonidas Jaber Bey, all rights reserved and retained in honor of my Moabite ancestors to time immemorial, exercising the divine and common law right to just post limine, in accordance with the high principles of love, truth, peace, freedom, and justice, as commanded by my holy prophet and guide, El Hajj Sharif Abdul Ali, Noble Drew Ali, I affix my autograph / signature here too. All right. Then I sign as consul, not to be confused with the Moorish American consulate, just consul pursuant to the treaty. Because I tried to teach the Moorish American consulate how to do things the right way, and they don't. They refused it. They rejected it. Anyway, Moors can never be and are not citizens of the United States Federal Corporation, C 28 U.S.C. 3002 15A. Denationalized Moors who are branded Negro, Blacks, Colored, Latino, and others, that's what Aliyah means, were lied to and told that the 14th Amendment was ratified in 1868, which was claimed to have reversed the Dred Scott versus Stanford case, stating that blacks were never intended to be and could never be U.S. citizens. The 14th Amendment was declared unconstitutional by the 90th Congress, First Session, Volume 113, Part 12, June 12, 1967, page 15641 of the Congressional Record. House Resolution 1203 of Georgia and House Resolution 0689 of Illinois recognize Moors as a separate nation of people, recognize Moorish Americans as being aboriginal and indigenous to the Americas, recognize Noble Drew Ali as a prophet, and further support the fact that Moorish Americans, as a result of the 13th Amendment with its 20 sections, were liberated from forced servitude, erroneously referred to as slavery. Period. Any questions? And no, you do not have to pay us for this, for your birthright. No, you do not have to pay us for this information that's on the public record. But if you don't believe us and you want to pay the Europeans for your Pacer account to get everything we filed with them to see the proof, then feel free to pay the Europeans. Look, someone say can't read without pointing at the words with his finger like a 5-year-old. That was funny. Any serious questions or statements? Oh, that's why they ended it.
Right.
Now all the trolls are on. Before there were no trolls. So they had to wake up their agents real quick.
So get out there and mob on them. Too much. Listening.
Oh man, they're mad. I wasn't even paying attention to that. I forget that there's an actual FBI COINTELPRO Pro against Moors and stuff like that. Literally, all the Moors are saying, yeah, they weren't even here before. Y'all are funny. That's funny. That's crazy, but it's funny. It blows my mind every time. I literally forget that FBI COINTELPRO Pro exists. Go to senate.gov, look up the Church Committee of 1975, click on the records, and you'll see thousands and thousands of pages worth of documents where Congress admits that COINTELPRO Pro is, alive, and they murdered Fred Hampton and stuff like that. They wrote anonymous letters to the El Ruckins and the Black Panther Party to get them to war with each other and stuff like that. Then if you look up Congresswoman Barbara Lee, Congresswoman Ilhan Omar, and Congresswoman Karen Bass, you'll see where they admitted in 2017 and 2019 that COINTELPRO 2.0 is on the rise to this day under the Trump administration. So you see that we're fighting all of that in federal court peacefully. So they have to have trolls come on here and say, well, no, whatever it is that they're saying, stupid stuff. Because they don't want you to see Moors filing claims in federal court as Moors peacefully, not threatening anyone. We're honoring the treaty of peace and friendship that our ancestors signed and the United States Europeans signed. We're in federal court as Moors. They recognize the Moorish ID. Don't even pay attention to what the trolls are saying, because they recognize the Moorish ID. That's why there's a Moorish name right here. In order to get into federal court, if you ever been to federal court, they need your ID. And we have about 20, right? 20 witnesses that came to court
Yes.
with us. X was there.
Right, 25.
Who was there? X was there. Izzy was there. John B was there. Amaryllis was there. Akeef was there. Juju was there. I was there. Was Moreno there?
Moreno was there.
Moreno Bay was there.
Abda was there.
Abda was there. Razin was there, right?
Razin was there, yes.
And his father. Their cousin was there. I can't remember his name. I think his name was King.
Oh, King was there too.
Oh yeah, that King. Both Kings were there.
Both Kings were there. Oh yeah, Razin, yeah.
Yeah.
And Hassan was there.
Hassan?
Yeah.
Oh yeah. His dad. That's why I said Hassan. Tafara was there too, right?
Tafara was there. Yep.
Tafara was there. I lost count, so I just stopped. All those Moors were witnessed. They seen us going to federal court with our Moorish IDs. Some Moors didn't even have to show IDs because there were so many of us.
And that's called precedence.
Yep.
We set a precedent.
Our Moorish IDs are recognized according to the United States laws. Look up 18 United States Code 1028D3. It'll talk about IDs issued by foreign governments were foreign to them. That's why I referenced House Resolution 1203 from Georgia and House Resolution 0689 from Illinois, recognizing Moors as a separate government, which means they have to recognize IDs, as well as Criminal Resource Manual from the United States Justice Department, subsection 1508, which references 18 USC 1028, which 18 USC 1028 is the basis upon which the Real ID Act of 2005 is based on. So they still have to recognize Moorish IDs pursuant to the Real ID Act, pursuant to United States Justice Department Criminal Resource Manual 1508, and United States Code Title 18, subsection 1028, letter D, number 3. Not because we're making laws up, that's because that's what the laws of the United States are, as well as the fact that we have the right to self-determination, we have the right to self-governance, we have the right to create our own IDs because we are a separate nation of people, etc., 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 etc. Any questions? What is fair as a counteroffer for the filing fee? Silver. If you go to United States or usdebtclock.org, click on the bottom right, it'll say precious metals, and it'll show you the actual value of the precious metals. So you can buy silver at 26 notes, but it's really like 5,000. It's really worth 5,000 because if you read House Resolution 5404 of the United States Congress, March 22nd, 2018, if I'm not mistaken, or 2017, one of them years, you'll see where the Congress admitted that the United States dollar has lost 96% of its value. So you can make a counter offer of 1 ounce of silver and they have to give you change, which is what we did. So they didn't give us change because they would have to give us like $4,000 worth of change. They just accepted the case pro bono. And like I said, you can go to you can pay for it, go to Pacer and pay these Europeans for this information. Since you don't believe us, it don't matter. We don't really care. We're still doing it.
Yeah, the Sheik want to see this stuff.
Oh, who's that? Another Moor. Look, another Moor is on the phone. So I gotta go. We got moves to make. Peace, Moors. Study, study, study. If you ask me what to study next, I'll say study Moors who know what they're talking about.